That's really what these isms are, however you want to fashion them. People have their own insecurities and they project out onto whomever happens to be, local or happens to be convenient, and as a result of that, you get these barriers and you get collectives, you get the KKK, you get the Black Panthers. I mean, you have any type of group that collectively pulls together for a common cause, i.e. I hate you, I hate what you stand for, and I think the law is no different from that. We have to protect the rights for those who have no rights. We are the voice for the voiceless. We are the people who stand up for the little person. And that was my primary focus when I filed the first water rate suit back in 2012. I looked at my $600 water bill for 1 month and I said, something's wrong with this picture. And why is it that this is allowed to happen? And no one had an answer for me. And so I said, well, clearly they're not using this money to run the water and sewer department, so they're taxing me, but they're calling it a water and sewer rate. And that's a violation of, I thought it was a violation of the Headley Amendment, which says, thou shalt not tax the people unless the people say it's okay. And so I filed you have to file the Headley cases in the Court of Appeals. I filed in the Court of Appeals, and I was sure that we had a dead bang winner. Well, Headley, as great as it was, has its flaws. And one of its flaws is the grandfather clause. And the grandfather clause says that if there is a rate or a charge or something that was in place at the time Headley was amended or ratified in 1978, then they get a pass. It's not covered by the Headley Amendment. So the Court of Appeals set the order to dismiss it.
Grandfathered in.
Yeah, you're able to pursue those rates and charges without it being viewed as an illegal tax. And so exactly. So what they did. That's right, and that was the language that says these are what we'll call pre-existing user fees that do not implicate the Headley Amendment, and therefore your case is dismissed. However, they then said in the rest of the paragraph, but if plaintiffs can prove these claims of illegal operations, raising the rates and using the money for other things, we don't have original jurisdiction for those claims, and the proper venue is circuit court. So that was on June 29th, 2012. On July 3rd, 2012, I filed suit in the circuit court saying this is what I think it is, and it's wrong. Well, it took the judge, I won't mention his name, 11 months to make a decision. Now, understand, we pled in there that people can't afford the increases, and because they can't afford the increases, they're not paying their bills, and when they're not paying their bills, they're getting the water cut off. It still took this judge 11 months to make a decision. In the meantime, I discovered through talking to people and not even taking formal discovery that there are 4 parts to your water bill. There's the service charge for water, service charge for sewer, the commodity charge, how much you actually use for both water and sewer. I discovered that in order, that according to ordinance, there needed to be what I'm going to call a rate table on file in the city clerk's office that said, depending upon the size of your pipe, this is how much you pay for your service charge for both water and sewer. And it's so that when you get your bill, you say, that looks a little high this month. I'm going to go down to City Hall and check on whether or not this is the right charge for my service charge. They had it for sewer, but not for water. So for all those years, they were collecting the water service charge without any legal authority to do so. So I asked the judge, I said, Judge, I want to amend my complaint. I want to add this additional part. Now, amending a complaint is like turning on a light switch. It's supposed to happen without a lot of thought, unless when the court looks at it and says, well, even if you amend the complaint, you can't collect on this claim and therefore it would be futile. That's one of the reasons you're allowed not to, as a judge, grant the request to amend. I filed that motion in December of 2012. It still took the judge until June of 2013 to issue his opinion. The opinion was, Washington, you lose. And you lose because I believe, the judge, that the emergency manager has unbridled authority and power to do anything. Now, the reason that that's significant is that when Mike Brown was appointed emergency manager, even though he wasn't in office and he didn't do it, when I said this water and sewer rate increase in September 2011 was illegal. And it was illegal because by ordinance you can only raise the water and sewer rates once a year, July 1st, and it's for 12 months going forward. You can't do it in September, which is what they did. And by the way, the amount that you're raising isn't in line with the ordinance either. He says, oh, so Mike Brown reaches back. He goes back in time, and he issues an order that says, oh, by the way, I ratify the rate increase of September 16, 2011. I said, where in the statute do you get that power to do that? How do you, exactly, that's it. How do you backdate it? And I was absolutely, you know, incensed that they would try that defense, but the judge walked. He says, I think the emergency manager did. I said, Judge, you're wrong. When I filed a motion asking him to reconsider, I said, the emergency manager is a creature of statute. If the power isn't in the statute, within the four corners, they can't do it. And he says, you're wrong. I said, okay. So I went to the Court of Appeals. I won't bore you with all the details in the interim, but the Court of Appeals ultimately said he was wrong, I was right, and they reversed it. And they said, send it back to circuit court. Because the other thing he did, which was inappropriate, is he says, I'm denying your motion to amend your complaint because its terms are inconsistent with this ruling. And the Court of Appeals said, that's not one of the reasons in the court rule, Judge. It's either futile or it should be granted. You can't just say, of course it's going to be in conflict because you're making the wrong decision. So they sent it back and they said, you have to make a decision. So it came back finally, took 6 months to get it back. But while we were waiting for the Court of Appeals to make its decision, we have something known as the statute of limitations. And that's the period of time from when something bad happens. For a specified period of time afterwards, you have the authority or you have the right to file a lawsuit. And if that time goes by and you don't file, you lose your right forever to file that lawsuit. And because I was uncertain as to what was going to happen, I filed a second rate suit on September the 15th of 2015, which was 3 years after the illegal increase. It was 2 years and 364 days. 1 day before my statute expired, I filed this new lawsuit. And I filed it and I went to the judge. I said, Judge, I filed this new case, let's go forward. The judge said, wait a minute. Why don't you introduce yourself, man? Everyone else introduced themselves around the table. I don't mean to point you out, but I'm Val.
Hi, Val. It's a pleasure. I'm Dr. P.
Hi, Val. Nice to see you.
Yeah, it's a pleasure to see you.
Okay. So I said, well, I got this case, I'm ready to go. He said, well, isn't this on appeal? I said, well, that's the other case. I said, I got new stuff. And he said, yeah, but I want to wait. So that was September, and we waited through the June 12th of 15 decision. The Court of Appeals reversed the decision and said, you know, it should come back. Then we went forward, and you may have seen some of the media stuff. We had a preliminary injunction hearing. The judge issued a preliminary injunction. The judge issued an order that certified the class of people in the second lawsuit. So, I mean, we now had a recognizable group of people, defined who were water and sewer customers at the appropriate time. And we were then able to go forward in that case to a point. There's something known as governmental immunity. It's an old holdover from English common law. And that it basically meant is that if you own some property and the king was on your property hunting your wild game illegally and killed a deer on your property, tough luck. King can do no wrong, therefore you're out one deer on your property. And that concept has been carried forward today, and it's actually in legislation, and it's called governmental immunity. The government can do no wrong. In the area of what we call torts. Now, torts are personal wrongs. In other words, you owe people a duty, you breach the duty, the breach of that duty causes harm. And that's what happens in car crashes, that's what happens when people fall down steps. That's what a tort case is. But I was suing for refunds. I said, I'm not asking for damages. Well, actually, the judge just dismissed my damages claim. So I'm no longer asking for damages. I just want the money that people have spent that they should not have had to spend. That's what I want. I want refunds. The city has been unjustly enriched by collecting this money that they're not entitled to and using it for illegal purposes, but that's another story. And so we filed what are known as cross motions. I filed my motion saying I should win, and he filed the motion saying it should be dismissed based upon governmental immunity. And there's a little quirk in the law, in the court rules, And that is, if a motion is filed seeking to dismiss a case based upon governmental immunity, and it's denied, the entity that raised that defense has an automatic right of appeal to the Court of Appeals. And in that automatic right, it stops everything in the lower court. So when they lost the motion, they filed their claim of appeal, and everything ground to a halt. I mean, we were 2 weeks away from a pretrial. We were going to talk about notice to the class and all sorts of things, ground to a halt. So we were stuck in my second case because now we're in the Court of Appeals and we're waiting for our opportunity to have oral argument. Back to the first case. In the first case, however, what we found is that when the judge got the case back finally in December of last year, I had to file a motion asking for permission to amend my complaint. And I talked with my opposing counsel, and he said, well, why don't you wait now? I mean, we really don't need this, because in the second case, the judge initially said that we had almost a 4-year period that these illegal actions were happening, and he narrowed it to 9 months. Literally going out the door, he narrowed it down to 9 months. So I'm thinking to myself, boy, 9 months is a whole lot different than 4 years. So in my second case, when I put together my amended complaint, I said, can't go forward, I can go backwards. And you have, instead of a 3-year statute of limitations for tort cases or damages, you have a 6-year statute of limitation for breach of contract. And so I went back 6 years, and it's a huge number. The money that they were collecting for the water service charge, it's tens of millions of dollars that they illegally collected. And so I filed a motion saying I want these tens of millions of dollars for the people in Flint. They filed a motion saying it should be dismissed because of governmental immunity again. And the judge is sitting on it. It's the same judge that took 11 months to make their first decision. And I was stuck with him. I had to go back to him. And so we're now waiting for his. So both water cases are stopped at this point. And it's my view that had this crisis, had these illegal raids happened in, Harbor Springs, Grand Rapids, even Ann Arbor, East Lansing, we would have some action. We would not have these tremendous delays because I think that there was a sense initially, people in Flint are too stupid to know that they've been done wrong, and as a result, we're going to do whatever we want to do as relates to rates, and we're still paying these high rates, and I don't know, and I've chased them now twice in the court about using the money for things other than water and sewer funds, which is exactly what the law says they can do, and they were not doing that initially. They were admitting and the trick that they would use is like, let's say this tabletop is one big bank account that the city of Flint had, and all your pieces of paper here would go into the bank account when money came in. So if you had money from the lighting assessment, you had money from public safety, you had money from whatever source, and you had water and sewer money that went in, all of it would go in, and they would account for it going in. But then, if the light bill came due, if the gas bill came due, they'd say, we need to write a check out of this, what they call the pooled cash account. So I said, okay, you account for it going in. How do you account for it going out? How do you know that that's a water dollar that you're leaving in there and not something else? And they said, well, we can do that. And I said, I don't think you can. So I chased in there and got the judge to issue a supplemental injunction that stopped them from doing that, because that was the way in which they were getting around the legal prohibitions on using water and sewer restricted revenues for general management. And the amount, and realistically, what people don't know is that Flint has been broke for a long time. We talk about it in general terms, but the numbers are staggering. In 2006, there was a $36 million positive fund balance in the sewer fund. In 2010, it was down to zero. And by 2012, it was a negative $2 million. Now, I don't know how you all run your household, but I can't write a check just because I got checks on my checking account, and I don't have the money in the bank account. I truly don't understand deficit spending. Yeah, but they don't. But they get hit. They get hit with fees, and that's the whole point. Well, I get that too.
Yeah.
So we found that this was going on. We tried to put a stop to it, and then along came the water quality cases, and you ask yourself, well, how could two communities, both under management by emergency managers, not be able to come to an agreement on letting Flint continue to draw water from Detroit Water and Sewer. How is that possible? And my answer to the question is, it's not possible. There had to be some hidden agenda there that prompted these types of actions on behalf of these emergency managers, because the numbers don't add up. Example, the Detroit Water and Sewer Department, through Sue McCormick, their CEO, wrote to Ed Kurtz in the 11th hour saying, hey, we will be giving you these rates that will save Flint $900 million over the next 25 years. Karagandhi, in which Flint is one member of many, says we're going to save all of our members $700 million over the next 25 years. And Kurtz's public response was, well, there were no rate guarantees from Detroit after the first year. Guess what? You're one vote of many. You don't have any rate guarantees over here either. And 900 million just to me versus 700 million that's got to be split. Again, the math isn't there. And the question becomes, why? I don't know factually why, but I have a theory. My theory is that somebody high up in state government wanted to break up the Detroit Water and Sewer Department. Because when they removed Flint from them as a customer, we were 6% of their volume. When we were removed, they weren't financially viable anymore. So they had to create the Great Lakes Water Authority, and they included Wayne, Macomb, Oakland, and Sinclair counties as members of this Great Lakes Water Authority. And you say, well, Val, how, that's conspiracy theory, you're kind of grasping. No, I'm not. The person who, I don't know if he still is, but was the CEO of the Great Lakes Water Authority is a guy named Robert Dadow. I don't know if anybody knows who Bob Dadow is. Very capable guy. I'm not saying anything about his qualifications, but for years he was the deputy county executive for Oakland County, the L. Brooks Patterson. So if Bob Dadow is now running the Great Lakes Water Authority, it's taken the authority to set rates, at least regionally, away from Detroit. I don't know, fill in the dots. I don't know that we'll ever get a true answer, but I can tell you this. As sure as I'm sitting here, when we saw Mr. Early in front of the House Oversight Committee, he committed perjury. And I say that because he said, I remember reading the transcript and I said, you gotta be kidding me. He says, I was told that the water was safe. That's a lie. It's an absolute lie. And I say that because on November 21st of 13, he wrote a report. Remember, emergency managers had to write reports. And he wrote a report to the treasurer with a copy to the governor that says, before we can use the Flint River as a viable source of drinking water, significant upgrades and improvements have to be made in the water treatment plant. Almost, I'm paraphrasing, but that was the language in that report. That's November 21st of 13, and that's 5 months before the cutover. On April the 8th, 2014, 2 weeks before the cutover, he wrote the same report with the same language to the same people. They made the switch on the 25th of April of 14. On July the 8th of 2014, he wrote the same report with the same language to the same people. How do you not know when you're creating the report? I'm not talking about something that someone else said. He signed the report, he sent it in. I got copies of the reports. They were on the website for a while. They're no longer there. But it's public information. How do you do that and then go in front of the committee and be under oath and say, I was told that the water was safe? You're lying. And I'm hoping that they do have a criminal investigation of all three emergency managers, because Kurtz, even though he's kind of under the radar, he's the guy who started this all.
Yes.
That's what I was thinking.
Yeah, he started it all because if you remember, when PA 4 was repealed, it stopped operating. So Brown had to resign right then, and he did resign. And Kurtz, because he wasn't eligible to be an emergency financial manager because he'd been acting mayor. And so Kurtz was appointed the emergency financial manager, let's say from November the 4th up to March 28th of 13. Why March 28th? Because that was the date that Public Act 436 went into effect in 2013, which replaced, PA 4. So during that time period, Kurtz was the emergency financial manager. So he had to get along, he had to work with people, he had to be cooperative. But one of the things he did in the latter stages of that was that he was talking to Jeff Wright, the drain commissioner, about how Flint could become a member of the Carragandi Water Authority. Well, everyone knew that Carragandi was still under construction. And that if he said, yeah, I'm going to join it, it's going to upset Detroit, and Detroit's going to end the contract, and then what do? And to say, well, we'll go to the Flint River is not an option when you have all of these studies saying that you have to increase. This was a part-time plan. It was, it was supposed to be a backup. How do you justify saying we can put our entire water distribution system, run it through it, without putting any money into it? I mean, that's the real kick here, is that you can't do it without putting literally millions of dollars in, and everyone said the same thing. So when all of this starts coming about, right at the end of his EFM time, Kurtz asks Andy Dillon, the state treasurer, for permission to enter into the Carragandi contract. He doesn't have to. There's a permissive section, I think it's subsection 3 of PA 140-1552, that allows for an emergency manager, if the contract is over $50,000, to seek permission from the state treasurer to enter into that contract. And apparently he did that. Even before PA 436 became effective, he sought permission. How do we know that? Because on March 26th, Andy Dillon wrote an email to Dan Wyant, the head of the MDEQ, saying, hey, what do you think about this whole, Flint going into the Carragandi, they have to use the Flint River? Well, Wyatt wrote back, all indications are that we are in favor of the KWA for Flint. The significance of that is that that same morning, Mr. Bush, who was the guy who's in charge of all of the chemistry and all the things for Flint in this area, wrote Wyant and said, if you go to the Flint River, you're going to have significant increases of microbial contamination and other pollutant contaminations, basically the trihalmethanes that became an issue with the chlorination. So why in the world would Wyant, knowing full well why the treasurer was asking him for that information, why would he give him that misinformation? I don't know. I really don't have an answer, other than it keeps Flint away from Detroit. So Wyant sends that information. PA 436 becomes effective on March 28th. On March 29th, Kurtz signs the contract to start buying capacity from Carragandi. One day after the act becomes effective, he signs the contract. Now, Dillon, to his credit, or discredit, again, based upon the information he had, then says to Kurtz, I'm going to give you permission, but I want Detroit to have one final opportunity to come to you with a rate package that you'll evaluate. And so on April 11th, the 13th, Dillon wrote his letter of approval with that language in there. And Kurtz got the proposal, a $900 million proposal from Detroit shortly thereafter. And then he completely discounted it because he didn't have to discuss it with anybody, didn't have to get anyone's approval. He was the emergency manager. He was all powerful, and that was the deal. So that's what happened in terms of how we got to the Carragandi, and how we are now going to, in my view, I don't think we're going to pay any less for water ever. But the reality is that I've asked, one of the things I've asked for in the rate cases, I want a rate study. And I want a rate study done by someone who's got national credentials, doesn't have a dog in this fight at all, to come in and just say, with what you've got in terms of the physical plant, what you've got in terms of operations and expenses and revenues, these are the rates that you should be charging. And, again, that we have to get stuck out of being stuck in stock before we can get any action from the courts. But those are the kinds of things that, are very prevalent today and, permeate every aspect of this. I mean, literally you have tens of thousands of people who have run to lawyers and who have, they say, oh, I want to be a part of the class action lawsuit. This is a catastrophe for which there is no judicial solution.
Yeah.
And what I mean by that, it's sort of like the asbestos cases. Once asbestos became known and all the exposure people have, what do? They set up funds.
Yeah.
And they said, if you have this kind of exposure, this is how much money you get. And people don't need lawyers to make their claims.
Yeah.
And they are still making claims to this day. But the reality is that when you circle the wagon, when you deny and you lie and you say we didn't do anything wrong, and you force people to go to lawyers, then then lawyers don't have any other venue other than the court system. You're going to go in the court system. And I think the real cynical view, and I hope I'm wrong on this, is that here in Michigan, the Republican Party controls the House, the Senate, the governor's mansion, in the Supreme Court.
Yes.
Yes.
And so, as the court of last resort, the Michigan Supreme Court is, it's predominantly Republican. So if people vote along party lines as opposed to what the law is, you have a potential for a harm visited on top of a harm. And then you have people who then say, I have no faith in the system anymore. And you know what happens when that occurs is that the anarchy is potentially there.